Hi, this is Advocate Lucinda. Did your employer terminate you and said they did not have to give you a reason for the termination? Or do you know someone who was terminated and their employer told them that they did not have to give cause for their termination? Well, it's true, but there are exceptions to that rule. So that's what we're going to talk about today: termination without cause and when it violates employment laws. So let's get started. In the majority of states in the United States, an employer can terminate an employee for any reason and without warning. In other words, with or without cause. That's called at will employment. According to the National Conference of State Legislatures, every employment relationship in the United States is at will, except in the state of Montana. Now, let me throw in this caveat. Remember my saying: always read the local rules and always read state law and rules as it relates to the issue at hand. Because in some states, employers are required to give the employee some explanation for their termination, a letter of termination, for example. So, despite this national presumption that every employment situation is at will except Montana, you always want to look at the state law in which the issue is at hand. So, in those states where the employer does not have to give the employee a reason for the termination, it cannot be motivated by discrimination. And next, I want to talk about some laws that protect employees from this at will relationship. The one that most of us are familiar with is Title VII. Title VII protects from employment discrimination based on race, color, religion, sex, national origin, age discrimination, and disability discrimination. If an employer terminates an employee on any one of these grounds, that employee could be held liable for discrimination. Another statute that protects employees is 42 U.S.C. 1981. It prohibits discrimination based on race, color, ethnicity when making and enforcing contracts. And an employment situation is considered a contract. It applies to all private employers and labor organizations. And one other thing I want to remind the viewers: 42 USC 1981 can also be filed simultaneously with Title VII discrimination. I have here 10 other labor laws that would protect employees from discrimination based on at will employment. I will include the link of these 10 laws at the bottom of the page of this video. Know your rights. Be empowered.